I heard there are limits to the amount I can recover for my injuries in a lawsuit in Cincinnati. What are they? In 2005, the Ohio legislature passed a new law which limits or caps the amount that an injured person can recover in certain situations. The bad news is that the new law restricts what many severely injured people can recover. The good news is that the law does not restrict recovery for some of the most severe injuries. And the law does not affect recovery for lawsuits where there is less than $250,000 in pain and suffering. Here is the way it works. In a personal injury lawsuit, you have always been able to recover your economic damages, basically medical bills and the pay you lost because you were in the accident. That hasn't changed. What has changed is the amount you can recover for your non-economic damages, that is, for the pain and suffering that the accident caused you. As of today, you cannot recover more than $250,000 for your pain and suffering. Or if your medical bills and lost wages are high enough, you may be able to recover $350,000 for non-economic damages. There are exceptions. The law does not limit your recovery for pain and suffering resulting from a wrongful death claim, from the loss of a bodily organ system, not just an organ. There is a terrible case stating that the caps apply if you lose only one eye. If you have lost the ability to care for yourself and perform life-sustaining activities. For the amount you can recover from the loss of the use of a limb, and from a permanent and substantial physical deformity. If your claim results from the type of injury listed above, the law does not limit your recovery. If you think you might have a lawsuit where you might be affected by the caps on recovery, speak with an experienced Cincinnati injury lawyer by calling 513-621-4775.